101.7 Asempa FM. So ni Ekosiisen dwumadi no asogu so a wotie no. We've done some 31 minutes after 6. The last leg of our conversation, and now the Supreme Court has ruled. In him say Supreme Court can in clear terms say the Honourable Member of Parliament cannot hold himself out as MP pending the determination of the substantive application before it. And the Yebusa said, what does it mean? Because the Biaka says Sisiano, the number of MPs are in the 8th Parliament now reduced from 275 to 274. ECB go ahead. I by election and lawyer Andy Apia Kubi.
In my opinion, say court judgment.
Yes.
It does not empower a party immediately.
Ekosiisen on Asempa
FM. You go through a
FM.
process of execution.
Okay.
And it is say on the records, judgment of the court, and a drew time I say going to execution. Notwithstanding application that also to relist.
Notwithstanding the substantive application before the Supreme Court.
The writ
Nankasa to interpret 94.2a.
94.2a.
Yeah.
It does not in any way affect the judgment in the instant court.
Okay, which is the High Court judgment.
And the execution process started from applications and the entry of judgment.
Yeah.
You serve it, and then a court parliamentary. In fact, you have to serve a copy on the
Speaker.
Clerk.
Okay, the Clerk of Parliament.
Clerk of Parliament. You bring to the notice of the Speaker. And but to the notice, the Speaker will also make a ruling on it and refer it to the Attorney General. Now, on the invoke the jurisdiction of Electoral Commission, so that the Electoral Commission will subsequently also start a process of preparing for a by-election.
Are you saying, sir, that process can kick in now?
It
Even when we are all waiting for Supreme Court to determine the substantive application.
Master, judgment now, High Court.
Yeah.
I write for execution.
Execution.
Next council can existence of a stay. Stay there, and yet single item. Bet me a file na ayejuma.
Okay.
Stay is upon a pending appeal. Appeal being the sabre ekase. It is stay no. But we explain say Bromo file stay no. Now there was a pending appeal. Appeal we had dismissed no there. It goes with the stay. Say application no and a releasement application. And it can go either way. But will not injunct the execution
of the High Court decision.
The High Court decision.
Okay.
And it lawyers started the process of execution. And when the say file entry of judgment and almost start service. So almost several judgment entry na eba clerk no notice to speaker will direct that EC should start the process. And judgment in itself alone doesn't invoke the jurisdiction of Electoral Commission.
Okay.
It's a go through process.
Okay.
The constitution at that point, me who a certain inadequacy be or constitution. Me feel it say, yes, I could start the whole process of, but any constitutional matter. As I say, debate on it, and say amendment, so would it be. Now, and Kaibani say to serve as a deterrent, send the Pabé me and send a coalition. So Bakuna ye unqualified. Why do we have to put extra burden on the otherwise qualified and second by way of voting? Now, RTNs are subjected to another round of preparation, campaigning, and all that. Now, yentimi exerted punishment on the first person who erred on the side of the law. And it can be feeling say there must be some amendments. Say, but said the first person here disqualified. The second person automatically should take over from the first person.
Okay.
So that we don't also spend time, energy, resource, and also somehow to the disadvantage of the second person.
I get you. I get you.
But the law does not provide for that. But I'm suggesting, sir, say a amendment be we should be looking at situations like that.
Situations like that. I get you. Thank you. Ma answer na lawyer Edwigita Maklobe Bamuno from the Office of Parliament, Honorable Eves Hansen Norte, MP Tema Central, or say Re Akufo-Addo must call Roads Minister to order over politics in Tema Central. Disclaimer by Honorable Eves Ninoy Hansen Norte. The statement says, my attention has been drawn to a press conference in which there is an allegation that the Honorable Kwesi Amoakwata, the Minister for Roads and Highways, together with his son, Oreku Amoakwata, were engaging in act of sabotage. We're engaging in act to sabotage my tenure as Member of Parliament for Tema Central constituency. I wish to emphatically state that such allegations are untrue and therefore comes as a shock to me. The Honourable Minister and I have been working tirelessly to ensure that all roads in the constituency are motorable. I therefore urge all and sundry to disregard the alleged rift and purported sabotage. The constituency is assured of my dedication to ensure its holistic development and to live up to my commitment to be a leader you can believe in. Signed, Eves Hansen Norte, MP, Tema Central.
We have to discourage publications. Eves, I will advise him to take that publisher on. Yes, because when you are indicting him, he hasn't said anything.
Yeah.
You put him out as saying something against his colleague. Media make catch Eves say on court now on site.
Publishers.
Publishing defamatory statements.
Yes.
Alleging that it is a statement attributable to him. It will continue to be like that. So a malicious statement and now the Babonti.
I get you. Thank you. Eduji, my memory, and before we come to even by-election issue, Idi Muhayuddin brought in an interesting perspective. It is our Articles 1302. The Supreme Court, the jurisdiction, interpretative jurisdiction, no, and on a clear. I think 33 in so and a case say when a lower court is faced with a situation a border on interpretation, they should stay and refer. On a case, there was a decision by the Supreme Court in ex parte Akosa. Court not sought to give some level of discretion to the presiding judge. Say a clear provision, a clear. Now you need be for interpretation. They should go ahead and deal with it. OJ, I'm not saying Eduji.
First of all, I it's very good sir we're raising this issue, but I wanted to address it. First of all, we share the Akosa formulation now. It has received subsequent judicial pronouncements. Okay. So for a long time, imprecision was the question whether the interpretative jurisdiction had been what. Now, Obibiawaye interpretation will tell you, sir, Barack, one of the things that he says is that even the decision that the word is precise is in itself an interpretative action.
Yeah.
And so the question of interpretation does not just arose because of your claim of imprecision. Yeah. That has been the position of the court. And in fact, in the case of Osei and the National Media Commission, the Supreme Court followed that the same proposition and said once the provision is clear, blah, blah, blah. Then the Supreme Court in February 2016, in the case of Emmanuel Noboku versus Attorney General, took the view, and in fact, the decision is clear that the court therefore departs from their decision in Osei and the National Media Commission and took the view that fluidity is not the threshold for the invocation of their jurisdiction. Remember that the Constitution is more like bifurcated. It is interpretation and enforcement. The doing of one does not mean, or is not at the exclusion of the other. Yeah. By seeking to interpret, you are basically seeking to enforce the Constitution. And so the courts have taken the view that to the extent that parties have put rival meanings to it. And so if you watch carefully, in this same Asenov case, Emra Court of Appeal refused to refer the constitutional matter, that refusal. Mr. Chikata filed a judicial review against that Court of Appeal. Yeah. The Supreme Court, by a 3-2 decision, took the view that since there was a pending Frank Davis writ, they will resolve that matter. So at the hearing of that supervisory application, my Lord Justice Poaman asked Frank Davis that, at the court below, when the issue of referral came, you oppose it. He said that is correct. Then the question then came that, by issuing this writ, are you not admitting that there is an issue for interpretation? And so if you read the dissenting opinion of my Lord Justice Poaman, this is what he says. And in fact, I have the argument here. So, an argument that where the framers of the Constitution met disqualification to operate on the basis of citizenship simplicity, they were expressed about it in a substantial point that the Supreme Court will need to take into account in determining what class of persons are targeted by Article 94(2)(a). He then proceeded to say that the High Court judge fell, quote unquote, into an error when he agreed with the lawyer for the petitioner that Zenator had already settled the matter. In the view of Justice Poaman, Zenator dealt with Article 94(1)(a) and not 94(2)(a). And that alone shows that the reliance on Zenator as the basis to determine the High Court matter will definitely be problematic. And that was why, if you look, he was willing to stay proceeding for the Court of Appeal to refer. And in fact, he even said that one of the powers of the Supreme Court is to refer the matter to itself. Because, Okaya, in Zenator, we didn't ask for referral. We only asked that the decision be quashed and then prohibit the High Court judge. Then the judges took the view that, yes, we've made a case for certiorari, because what he purported to have done by interpreting 94 or proceeding to was error of law patent on the face of the record. So by 4-1 decision, they agreed with me. Then refer the constitutional matter
to themselves.
So in this 3-2 decision, the Supreme Court took the view that no, the Court of Appeal ought to have stayed and referred the matter to the Supreme Court for interpretation. And that the mere fact that Mr. Frank Davis, as lawyer for the same plaintiff, that's the petitioner in the High Court, had issued a writ for interpretation, it means that he himself admits there's a question of interpretation. So with respect to
any student who
I will plead with him, obviously is problematic. So I'll plead with him that he should look at Emmanuel Noboko versus Attorney General.
And only a more current.
2016. Okay. Expert Akosa is 1980s decision. Osha, the court had subsequently, because you see, one of the things that lawyers were doing even in Supreme Court was that anytime you issue a writ, we'll raise a preliminary legal objection that, the provision does not admit of any ambiguity. So if anything at all, go to the High Court. That has been the position. Or Sebwatch in National Media Commission. So now you notice that even the Supreme Court now doesn't take objection to jurisdiction. They consolidate everything. So that if they admit that there is jurisdictional issue, then they will stop at that. If they don't, then they will consolidate.
So now he's coming to agree with me on the process that I suggested.
Sir, and can you not go the route of an election petition? Go Supreme Court straight.
No,
but he made that point.
Yes, I agree. No, but the point I'm making is that the Supreme Court has also, and the law is that where a particular forum is provided for to vindicate a particular right. If you go outside that right,
but this forum,
your process will be struck.
No. This one,
wait
a minute. This one, the complaint is not on the election and the malpractices.
Or direct on 94(2)(a) interpretation. That was seeking consequential orders from the court.
Because this application is not bordered on irregularities.
Article 97 today. Article 97.
It's not bordered on irregularities.
No, 97.
It's bordered on.
97
constitutional
tenure of office of members.
Yes.
97(1). A member of parliament shall vacate his seat in parliament.
97. it should be tenure of office of members.
Yes.
If you have a problem with
you're
a
going beyond
parliamentary election challenger,
Okay.
No.
A person has been okay. The account has said blah blah blah.
97
blah,
is
blah,
of
blah,
tenure
blah,
of
blah.
office of members.
Okay.
upon-
No,
and
I
the
think a
address of
person
application.
aggrieved by the determination of the High Court under this. Okay, may appeal to the Court of Appeal. No.
before then.
Yeah, before then.
Before then, you go to with a petition to a high court. But what I'm saying is that there is an issue of interpretation in this particular question matter.
Yes.
So I would have gone because they are now going after exhausting the jurisdiction of the High Court, the Court of Appeal.
Yeah.
But I'm saying because of the interpretational issue in it, you could have gone to Supreme Court for that interpretation. That
Now,
which they
we're
agreed.
asking for consequential
Then
orders.
as for consequential
So
orders.
that is why we are at the High Court, like I told you, at the injunction hearing.
Yeah.
The position canvassed before the court was that allegiance was quite different
From citizenship.
Exactly.
we
And
have
for that
we
matter-
have exhausted
and-
the
and-
argument.
no,
of-
no,
I'm just trying to draw the distinction. And for that matter, he ought to have stayed proceedings and referred. And this
referred.
on record.
for determination of
So that one the Supreme Court, the
Of
interpretation
94
of 94 to
oh, okay, that's what I'm saying.
Yeah.
So that is the same action, but just that it's a referral
Yeah.
that is giving root.
In the Supreme Court, they interpret it.
Then it would have been binding on all
All
other
the lower
courts.
courts.
Then
You
the High Court judge refused that Zenato had already interpreted it
that.
because lawyers for the petitioner took the view that Zenato had resolved their matter. So the High Court judge can. Now, the same people who then said Zenato had resolved the matter
Now goes back to
now
the
have
Supreme
now
Court.
issued a writ for
You
interpretation. So
understand?
when it
Why
came
would
for
you follow
the
them?
supervisory jurisdiction, my Lord Puaman asks that by reason of this writ that you have filed at the Supreme Court,
Ekosiisen on
are you not
Asempa
admitting by the writ that there is a genuine
Assuming
question
he is
of
even
interpretation?
admitted,
interpretation.
doesn't he have a right?
So why
to
oppose
file-
it at the High Court?
You can oppose it today
And
but-
change your mind?
And change your mind. I mean, you cannot stay there.
Should we expect a by-election?
Yes.
Would it be legal based on the ruling, ENRA?
You see, I would take consolation in the views expressed by my Lord Justice Nana Megache,
Okay.
where he makes the point that this ruling may have the unintended consequence of having prejudged the matter, in the sense that, you see, now you have technically or whatever by the order said the man should not hold himself out. So the people of Asinov will be without
Representation for now.
So assuming for the sake of argument that this application, nobody knows tomorrow, the rates, it can stay there for 6 months.
So, well, but I know so we can
We have a return date already. Don't
No,
forget.
the court
that-
said
Omo
they
man
should
date.
file.
Omo
No,
so
they
omo file
file
it.
it by 25th of send a friend by 25th of April.
of April,
But-
and then no mama date for the hearing.
But I have done matters where you go and the court will say, look,
Ekosiisen
judgment
on
is not
Asempa
ready.
FM.
Go and come back. Adjourn for judgment. It has happened.
Yes, but when we have
But
this, you
all
only
this
have to
period,
wait.
all this period, what then happens to the people of
to the
Ascent?
people of Ascend North.
What
Yeah, but
happens?
look,
Then
the
the
law
EC
makes provision.
Then the EC should go ahead and organize a by-election.
Okay, so the Electoral Commission, if you look, who is the second
Second,
respondent or defendant?
defendant.
It's the
yes.
Electoral Commission.
Yes.
So the writ that is pending before the Supreme Court, awaiting determination, the Electoral
EC
Commission
can
is a
help.
party. So on what basis will the Electoral Commission proceed?
Go ahead with the by-election.
Yes, but,
On what
but the
basis?
pendency of the interpretive application doesn't stall
How?
or stay
The execution of the High Court
of the
ruling.
High Court.
You think so?
No, there are different processes. You understand? Because you don't, when you file a process, it doesn't give you the power of determination of another process. You understand? Because they are not contaminants. This one is a different application before the Supreme Court. And that one is a process that resulted in a judgment. Not until there's an appeal on that. And indeed, this application doesn't operate as an appeal to the
High Court.
to the High Court judgment.
How?
Yes, it doesn't operate as such.
How?
But this is an application for interpretation. It can be this or can be that. It can be. How does it
So,
stay this?
Senior, per your long practice.
Yes.
Your long practice. there is a policy reason why, for instance, presidential elections, the president whose election is being challenged is not injuncted
Yes.
from performing.
Yes.
This is the
I'm just saying.
directive principles of state policy.
No, it's not an issue of
Yes, because you cannot have
you don't want to create a
stateless-
constitutional crisis.
Yes.
Yes.
Because the people of Asinov requires representation. In fact, I recall when
And therefore,
we issued
somebody-
we filed
somebody
the writ.
illegally-
No, just a minute. We filed the writ, the petition, Techiman South. We added an application to injunct Martina J. Kosa. Then the judge said, look, the people of Techiman South,
Omuhia
they
representation.
need representation until the petition is determined. And that was why the injunction application was refused. If you recall, Peter Mewu, you remember there was an initial injunction.
Yeah.
What happened subsequently?
It was squashed.
It
by
was squashed.
Secretarial application.
Whole High Court, not
Yes,
say,
yes.
Yes,
the Supreme
because
Court.
you do
Supreme
not
Court
want to
quashed, yeah.
deny.
It is not because
Senior hold.
they didn't want
You
to
do
deny.
not want to deny
No,
the
that's not
people
the reason.
representation. And I'm saying that the High Court had done a similar thing in Techiman South. Because you see, the issue of representation,
issues are different, though.
Senior, the issue of representation is at the core of our
Of
democratic
our democracy,
process.
yeah.
And the danger is that,
So how
assuming
about
without
if-
admitting,
how about if somebody dies?
Oh, the senior, assuming that's why there's the need for by-election.
By-election.
Yes. So the
At
law
this
has
point,
made
is there
provision.
any by-election?
There's no by-election
So the
because
lacuna created, how do you feel the voice?
so we have to allow.
Senior, how do you
the-
feel the voice?
So then we allow the EC to
the law
organize the
allows for
by-election.
No, but the EC is a party
It's
to
a
this
party
suit.
to the suit.
What
But-
will be the authority of the Electoral Commission to proceed?
No,
When the person died and is an MP,
Yeah.
immediately the clerk of parliament notifies the
The
EC.
EC.
What will be the basis for the clerk of parliament to notify the Electoral Commission?
The High
the
Court,
High
the
Court
High Court
judgment.
decision.
Good.
High Court
So
judgment.
that is why, if you notice, even at the court, the Electoral Commission, that was the third defendant, said, why are you here? You claim you have a judgment from the High Court, right? That's your claim. So if you have a
Yeah,
judgment,
but
oh no,
notwithstanding your claim,
if you
somebody
claim
brings you
that,
before the
if you
court.
claim that
You are
you
saying
have,
that you won't go.
no, that's the petitioner itself, the plaintiff.
Yeah.
You claim you have a judgment
From the High Court.
High Court. So if you have a valid judgment subsisting,
Execute same.
execute same. What are you doing at the Supreme Court? Two, Obi, if you claim you have a judgment, what is the essence of the interpretation? When the High Court judge has said that the constitutional provision is precise,
It could be for academic exercise.
that is why, Madam, what's the name? So if you are doing academic exercise, you grant an injunction on academic exercise.
The application
So,
provision
Sina,
is different.
I can tell, you see, you are beginning to appreciate.
I'm not beginning to
you know,
appreciate. Me, I have given my strategy.
Obi, you
if
see,
I was.
you are beginning to
But
appreciate.
listen,
Because
all
you see,
these things have
all
been
the
done.
relief, all
could
the
have been
relief,
done before.
all the relief that were granted by the High Court judge were the same relief. The same petitioner now turned plaintiff is now asking the Supreme Court for the same thing. You claim you have a valid judgment.
Why are you in the Supreme
Why are you in the Supreme Court? Go and enforce it. We all know, and every
That could
practitioner
be-
knows
that could be
that when you have
One
a
part of
judgment,
the advice. But
when you have a
notwithstanding
judgment-
my rights of execution, I still want the
Ekosiisen
Supreme
on
Court
Asempa
to
FM.
interpret this constitutional matters.
you and I know.
You
that-
see,
you
so
and
that
I
does
know,
not
you and I
injunction.
know that the Supreme Court has always said that it does not offer advisory opinion.
No. For now,
You
I can
know
go
that
to
the Supreme Court doesn't
no.
offer advisory opinion.
They can-
You and I cannot just go and say, "Oh my Lord, we anticipate the
No.
possibility of 94. So please interpret it for us as a guide."
In the Edu Jimmy Pacho was say your friend is saying, say clerk of parliament and notify electoral commission. Say they've taken notice of the Supreme Court ruling.
Yes.
And they think
They've been served with entry of judgment.
Yes, and they think the EC should go ahead and organize a by-election. Would you challenge that? Mobile challenge it.
If the Electoral Commission says, and remember that to declare vacant a parliamentary
Yeah.
seat is the prerogative of the Speaker.
Absolutely.
Order 1819
Yes.
of the standing orders.
Yes.
Now, if the Speaker says that the seat is deemed
Vacant.
and the various processes are triggered, as a political party, we have to get ready for it.
Go and get ready. that's all.
You will not challenge it.
No, we have
You
to
will
get
not
ready.
advise your party to challenge it.
What will be the basis?
that the EC is part of the suit pending before the Supreme Court.
You see,
which suit?
They were even anticipating an application by the respondents to the Supreme Court for interpretation. That is why probably the plaintiff probably was anticipating that you may want to trigger that.
No, that is why we asked for referral.
Okay.
You see, and you didn't get it. So
and the High Court, no, they opposed it. It's not like we didn't get it.
As for
They
what happened,
opposed it. That is why I'm saying that. You see, if
as for what happened in the High Court, it's already done.
The first objection with that, and I'm abusing the court process, and I'm
so go and do that application.
I'm forum shopping.
Go and do that, and let's see the results.
Even you in your practice, you have never enforced a High Court judgment at the Supreme Court. Because by the time you get there, the judges will ask you.
We are long past this.
Are you sure?
We are long past this issue because
this is a special dispensation.
Because the judge who is even complaining is saying that he's being innovative.
That no, he rather said the Supreme Court is not a forum for legal ingenuity.
Yes, but again, having said that, his brothers on the bench ruled that it is proper.
Oh, of course. And
therefore, for me, I take it as an attempt to expand procedure, which we can also invoke.
Mankind something quickly now.
Finally,
the grant of this relief sought by the applicant will have the effect of disqualifying the first respondent from occupying his seat in Parliament of Ghana and representing the people of Asinov. Until the final determination of the rate, we are in the interim being invited to restrain the first respondent from performing his duties in Parliament. In my opinion,
legal duties.
The net effect of acceding to this interim invitation would also temporarily achieve the same results as the relief being sought in the substantive rate before this court. The reasons advanced for this invitation could be gleaned from the affidavit in support. In the first place, the High Court had delivered a judgment. If you have any problem, seek to enforce it.
Enforce that judgment. Obi, my simple question to lawyer Eduje, between the time that Honorable Adamu Sakande was asked from Parliament and the day of the by-election, who represented the people of Boko? Again, if an MP dies, who represents his constituent until a by-election is held? Dr. Dakwa, LDC.
For instance, Dr. Dakwa, with the respect, Okaya, Embra Erika Mwati, conviction of bias. His lawyers wrote to Speaker Amwasich because then he had done the 15 days more.
Yes.
And they wrote to Speaker Sechi Hughes, sorry. And Omo can say he should be granted leave of absence, indefinite leave of absence. Into Omo, yes, sir.
And I'm as I recall court.
Exactly. As I recall court, it went to the Court of Appeal. And the Court of Appeal said, no, 15 days is 15 days. Who exempt here? They seat, quote unquote, becomes vacant. What do I say?
Yes.
Now, once that happens, like the points raised, which are your constitutional process, and members in kind of pay out. Recent, I also was working. MP no a few.
Yes.
Parliament and notify through the clerk EC.
There's a process.
You know, EC even delayed.
Yes.
In even organizing the by-election. Which are the Constitution said within 21 days.
21 days.
This Supreme Court matter. What time will it be resolved? The framers of the Constitution anticipated a situation where there can be death, there can be vacancy. But almost say, within 21 days, that position should be filled.
Yeah.
Now, with the Supreme Court decision, does it not overreach the 21 days? Because there wouldn't be any representation for the people of Asinov. So that if this application or the rate is going to take 2 months to be resolved, we are past the 21 days. There is no by-election. There is no representation for the people.
But why do you
so
come to that conclusion?
But
maybe once we start the execution process, why do you anticipate that?
Which execution?
High Court judgment.
So if there is High Court judgment, you see,
the
confusion we have created.
So
are they going to withdraw the rate
at the Supreme Court?
At the Supreme Court?
No, the Supreme Court rate is for interpretation of the Constitution, and the High Court judgment is ready for enforcement.
It will have the net effect of deciding the
So
matter.
assuming they didn't even go to Supreme Court for this interpretive application, wouldn't they go into execution?
So essentially, what they have done is to overreach
look,
all the
if
matters
I was
that
the
are
lawyer
pending.
in the case, I would start execution long ago. When they threw out the appeal. So for me, they don't need to wait.
So you basically are admitting that the process that they have
has a right
is
to apply.
problematic.
Madam Ase, lawyer Edwin Tamaklo. Yes.
30 seconds on the issue of Sakande, and it keeps coming up. With the greatest respect,
Don't go there. It's
he's
okay.
a dead person. I usually mean person kind of be for you. What we should know is say as at 2009, okay, February, Sakande was still using his passport.
Yeah, the facts are different.
Well,
I get
the
you.
facts are
I get
different,
you.
but
I get you.
they should go.
They should go and enforce.
Go and enforce.
Mate, Ekosiisen, you did you do any AC here?
Nobody's right to seek interpretation on any part of the
Supreme
Constitution.
Court is not that.